You're an AOR client, you've just been involved in a self-defense incident. How do we decide whether you're covered? A lot of information coming your way. Stay tuned. This is attorney Andy Marcantel and attorney Marc J. Victor. We're the partners of the Attorneys for Freedom Law Firm, here today to answer some questions that we've gotten a lot of regarding coverage in our program. How you doing today, Marc?
Good, man. A lot of people are asking, how do we decide, how do we make this decision about whether or not it's a self-defense related legal matter? I wish they knew us better, right? I mean, that's kind of where I start because, if they came here and they met our team and they were actually sitting in on our attorney meetings.
Or spoke to any of our thousands of prior clients over the years.
Yeah, if they were really intimate with what our firm is about, they wouldn't be asking this question.
That's right.
They would know that we like doing what we do, right? So I guess at the outset, it's important to say we're not looking for reasons to deny having to represent people. Like, we want to represent people. That's what we do, right? We got a staff of lawyers and paralegals who came to our firm because what's in their head is, I don't want to work at a McDonald's kind of place where they're just holding people's hands and walking them through the system. I want to go to a place where I got real criminal defense lawyers.
Who love what they do.
Yeah, who like to bring creative motions, like to sort of show off the fact that they're good lawyers. And we like to go to court. We like to argue. We like to bring creative motions. When we lose, we like to appeal. We like to keep fighting and fighting, kind of like the Terminator.
You could say
right?
we're sore losers in that sense. But
Yeah.
yes, we want to push it all the way as far as we possibly can in every single case for our clients.
Yeah, if we can make new law along the way, we're excited about that. But we've said it in some other videos, kind of our attitude about doing criminal defense. I've said on a few occasions, we're lawyers first. And we really are lawyers first because we like our craft. We went to law school thinking about doing criminal defense. We like fighting the state. And so when a case comes in, when that emergency call comes, and we just had one yesterday, everybody's excited, right?
We're all kind of fighting over who gets to work on the case.
Yeah, the message comes through, strike force, assemble, and everybody's pumped up, right? Who is it? What's going on?
That's literally what we send to each other when an emergency call comes in. We call our team the strike force. You guys may know that if you've seen our video. We'll put a link down in the description. But the question is, what happens when I call? I have the self-defense emergency. I called the hotline. We made a video about what happens, and we call our team the strike force.
Yeah, Rachel took it the other day, one of our lawyers, and I remember seeing it on my phone, strike forces. So I thought, wow, I hope this is a good one. Look, we're criminal defense lawyers. We like doing criminal defense cases, right? If it was a first-degree murder case, I don't know how these other companies or whatever, their attitude must be, oh my God, we got to pay a bunch of money to some lawyer. What I think about is, wow, this could be a great opportunity for us to go out and get in a nice, juicy first-degree murder case. And I've done a bunch of first-degree murder cases. I know what they're like. I've been through them. They're hard. There's a lot of work, but it's what we do. And so if that was the case, every single lawyer at our firm is going to be pumped up about doing that. Okay, so, but we don't cover everything under the Attorneys on Retainer program.
Yeah, this question that we're addressing today comes from that because we got three criteria of when it's a covered legal incident. The incident has to have occurred after you signed up on the program.
This is a no-brainer, right? We've had a few people, just to be fair about it, who have tried to get one over on us here, right? Like something happens, and then they go out and quickly join AOR, and then they may get arrested or something, and then they call us. I just got arrested. I signed up a few days ago. Okay, well, maybe it just happened after you signed up, but it's not like we're not going to find out about this. We'll still represent you. We're still a law firm. You can pay us. You don't even get the 35% discount then because it happened before you sign up. So sorry, but you can still hire us to do the case. That's what we do. In fact, we'd be happy to do the case. You just got to pay us to do the case.
Yep.
So it has to happen after you signed up. That seems pretty obvious. You have to either be charged with a crime, felony or misdemeanor, or, I think as we say in the contract, reasonably concerned about being charged with a crime.
Yeah, that covers all those pre-charge incidents that we talk about all the time, right? Where we're representing somebody before a charging decision is made, which is also covered under our plan. As long as there's been an incident and you reasonably expect you're going to be charged, no problem, you're going to be covered under the plan.
Yeah, right from that first phone call. And even if you don't get charged and say it was a valid act of self-defense and there's a bad guy out there who you were acting in self-defense against, then the bad guy gets charged, we'll still represent you as a victim in the criminal case. And so I think a lot of people forget about that. To my knowledge, there are no other companies that do this.
And that's also covered 100%, all
Everything.
fees, all charges, everything like that, covered by the plan.
Yeah, those are fun too. I mean, we have cases ongoing at our firm that we represent victims on, and well, maybe not as fun as being in the first chair seat on a criminal defense case. It can be fun to come into court and pound the table and cause a little bit of chaos in court on behalf of the victim. So we love doing that stuff.
Yeah.
We do that as well.
So that's 1 and 2. Those are the first 2 factors that you got to sign up before the incident, and you have to either be charged or reasonably expect to be charged. But today's video, Mark, is to address this third criteria that we have for coverage under the Attorneys on Retainer program, and that is that you reasonably or in good faith acted in self-defense during the incident.
Yeah, and it's sort of hard to word this. If we were going to, try to be more precise here, and I guess that's what we're doing with this video. We're trying to be more precise. Who are we trying to exclude? Let me tell you who we're trying to exclude. If you are in a criminal street gang and you are planning to commit crimes and you're thinking, oh, I can just sign up in the Attorneys on Retainer program and then I can go commit crimes and I'll get the Attorneys for Freedom law firm to defend me for free, that's who we're trying to exclude, right? So if you're intending to commit a crime, we're going to exclude you, if that's what your intent is. If you're planning to go in and rob a bank and you stick a gun in a teller's face and then you come in here and say, oh, I acted in self-defense, we're going to exclude you. And I don't feel bad about it. The program is not for that person.
That's right.
But if you, in good faith, acted or tried to act in self-defense, that's the best way we should say. You, in good faith, tried to act in self-defense. And usually I say, right on the heels of that, but you blew it. You actually committed a crime, right?
Even if you screwed up the self-defense analysis.
Even if you screwed up, we don't exclude you. And this is, I think, one of the big differences, one of the many big differences, frankly, between AOR and I think every other program out there. That's not a problem for us. We don't have insurance licenses where we're worried about getting those revoked because we are covering a criminal act. We have licenses to practice law that we are specifically allowed, and the Constitution guarantees the right of a criminal defendant to have effective assistance of counsel to represent people. That's what we do. So even if you blew it, if you just say, look, I tried, maybe I was drunk at the time, I reacted too slowly, the guy turned around and I shot him in the back, it was dark and I didn't know what was going on or something like that, no problem. We don't have any of these exclusions. We could go through the whole laundry list of exclusions, right? Illegal firearm, it happened at a place where...
You're in a sensitive place, which is becoming more and more popular these days among certain jurisdictions.
It was domestic violence, which a lot of these cases are.
Problem with the weapon, illegal weapon, serial number problems, stuff like that.
Yeah, there's a whole bunch of you're a prohibited possessor. We don't exclude any of that stuff. We're happy to represent you. If you tried to act in self-defense, no problem. We're going to jump in and do everything we possibly can to give you a defense that is second to none. We are not going to take a back seat to anyone. I don't care who you hire. I don't care how many lawyers you bring. I don't care how much money you spend on the case. We will give equal or better as far as defense to that person. That's our attitude about it. We're not going to be second fiddle to anybody.
Yeah, so all we really care about is that the person attempted to act in self-defense. That's good enough for us as long as we can bring that in court. So to say a few things about that, what does that mean to be able to bring it in court? We need to be able to argue self-defense as a defense to the crime that our client is charged with. Oftentimes this comes in the form of what we would call a jury instruction. And just to explain what that means to people, whenever there's a trial for a criminal case, the judge is going to turn to the jury and give them the instructions in the law that they are required to follow in making their jury determination. And if you want to raise a defense under the law, you need to be able to get the judge to tell that instruction to the jury. So how do we know if you can raise these? Well, it's something that's determined way ahead of time, way ahead of trial. This isn't something where we're hoping or guessing whether on the day of trial the judge is going to allow us to argue is self-defense. No, that's ridiculous. What a good lawyer does is they make sure way ahead of the trial that there is a legal determination made by the court that, yes, you may argue self-defense to the jury.
Yeah, in most cases, it's going to be pretty clear, right? Because you have to make a prima facie case, a showing, which can easily be satisfied if the defendant is going to get on the stand and say, you know what, I acted in self-defense. That's usually all you need to now invoke self-defense, which will then put the burden back on the state or the government or the Commonwealth or the people to now disprove self-defense.
So let's flesh that out a little bit. It's a pretty low bar here. It's
Yes.
a pretty low bar.
Yeah.
When you have a crime, now, granted, there are certain crimes for which self-defense isn't even legally an option. So, for example, let's say that there's a burglary. What you just described, the thug who goes and sticks the gun in the teller's face at the bank. Let's say there's an armed robbery, for an example. Well, self-defense is not a justification defense for armed robbery. Said another way, you can't say, I robbed that person at gunpoint in self-defense.
Right.
There are actually other defenses,
Yeah.
like, say, you were forced to do it or
Duress
something
or
like that,
something.
duress and necessity and things like that may be available, but self-defense is not something that's
insanity
available.
could be another defense. You got to be able to raise self-defense. If you stole a car and you're charged with theft or grand theft, and you are an AOR client and you come in and say, hey, I acted in self-defense, we're going to say, sorry, we can't bring that as a legal defense. Now, you can still, as a non-self-defense related legal matter, you can still hire us. You get 35% off the attorney's hourly rate. You got to pay for everything else. But that's what we would give, friend, family member, somebody who calls up who's kind of on the inside, a discount because we like them. 35% is about the place where, all right, we're probably not losing any money. We're probably not making any money, maybe a little bit. It's not a big money maker for us, but no problem. We offer that to our attorneys on retainer clients. But it's not going to be a self-defense related matter because you can't raise self-defense to the particular charge.
Yeah, so back to this issue of how easy it is, and I'll use that term. It's not a legal term of art, but how easy it is for us to get a court to give us a self-defense instruction. One, it has to be legally available. We just talked about that. And two, the person has to say, I acted in self-defense. I tried to act in self-defense. Good enough for the vast majority of jurisdictions in the United States. And if we can get a jury instruction, that's all if we can get a jury instruction, we're golden.
Yep.
We can represent that case, and it's going to be covered under our program.
Yep. Now, there are some cases that come in where maybe the defendant is not going to testify for some reason. Maybe they got 15 prior felony convictions or something that would otherwise come before the jury, and instead they're not going to testify. And again, this is maybe some inside baseball, but when somebody testifies, their record, criminal convictions, is generally fair game for impeachment. And so if you want to keep that out from having
in other words, the prosecutor can bring it up in front of the jury. So let's say somebody gets on the stand and says, I acted in self-defense, but they got 15 criminal priors on cross-examination in front of the jury for impeachment purposes, and otherwise to impeach their credibility
That's right.
as a witness. The prosecutor can bring it up and say, sir or madam, isn't it true that you have 15 violent criminal cases, convictions against you? And they can bring that up in front of the jury.
For the legal geeks and legal nerds out there, yes, we know there are some limitations, time limitations, and other issues that may require what we call sanitizing priors or things like that. But generally speaking, if the defendant has some baggage that we don't want a jury here, we might keep the defendant sort of sitting in the chair instead of testifying. So now you may have a little bit harder question about bringing self-defense. There might be other witnesses who saw things that might make it easy, but maybe not. And so it can be a close call about whether you can argue self-defense. And I think, in these types of cases, normally what you can do is ask the judge in a pre-trial motion, maybe even a motion for jury instruction of self-defense, get a preliminary ruling on something like that. But to be fair, in a close call, we're always going to err on the side of representing people.
Let's talk about how the free market works, Mark.
We're not confused. Look, we are both free market capitalists, right? We believe in the free market. This is part of being attorneys for freedom, right? People should be allowed to trade. We also think information flows freely. We're not confused about what has happened to some other companies who have failed to cover people that, at least arguably should have been covered. And I think understandably people feel like I don't want to be guessing about whether or not if I have a problem and I'm charged with a crime, I have to worry about whether some insurance company or some other company is going to leave me high and dry. So we're not confused about that. If we were to not cover somebody in a close case, right? Because we know the people who sign up in the Attorneys on Retainer program are people, a lot of them have left other programs. They're all concerned about being left high and dry. They're all concerned about not having an attorney when you need an attorney. We know why they're joining the Attorneys on Retainer program. If we screw that up, right, a close call, and we say, we could probably weasel out of this one if we wanted to, we know that information is going to get out to the market.
That would be the end of our program.
Yes.
The reason why people are joining our program is because they have these problems about being excluded and these concerns about being excluded from these other programs. We understand that. We're acutely aware that if we failed to keep our end of the deal and we failed to represent somebody who was involved in the self-defense shooting, that'd be the end of our program.
And it
Done.
should be.
It should be. Yeah,
yes,
it absolutely should be.
It should be the end of our program if that was the case. So if we are to decline somebody, it's going to be because either they're not an active member, they didn't pay their dues or something like that. It happened before they joined up in AOR, or it actually is crystal clear, which means if that case goes to trial, there's not going to be a self-defense jury instruction in that case. Because if there's a self-defense jury instruction, what that says is the judge has found that it's not a frivolous argument.
That's right.
And so it's going to have to be something so clear that a judge, upon being asked, hey, judge, will you instruct the jury on self-defense? The judge, knowing he or she could be reversed on appeal, is going to say, nope, there's just no evidence whatsoever that a reasonable jury could come back and find self-defense. I'm not giving that instruction.
But even in that hypothetical that you just described, I would still be inclined to continue on with the defense in that case, even if it's not technically, even if we could weasel out of it, just for the possibility that on appeal we raise that as a potential post-conviction relief issue. I would want to err on the side of seeing that case to the end.
That's what I was just going to say. In a close call, we, not just for contractual reasons, not just for we like doing this stuff reasons, but for business reasons, we are going to err on the side of representing that person.
Yeah, let's talk about this for a second. This is really, really, really important. If you would ask a number of our active AOR clients around the country right now who we're covering, they would tell you that we tend to go the opposite direction when we're assessing a case for whether or not it's covered under the program. And we tend to bend a little bit and say, even though it's slightly outside of the lines, we'd rather err on the side of covering. And there's lots of reasons that we do. That's business-related reasons for sure, but it's also, frankly, selfish reasons that we like doing these types of cases. We actually love representing people in these types of cases.
Yeah, and I think it's important to say, and I know we've said it before, we're in a completely different position than every other one of these companies that's got to open the checkbook and write a probably pretty substantial check, right? If the case is going to go to trial, and I don't know if these other companies are getting quality lawyers or not, but my current hourly rate is $850 an hour. And so think about how many hours go into prepping a serious major felony self-defense kind of case. They're going to write a check that's going to be north of $250,000. And so they got to really think about that. Do we want to write that kind of check? For us to do the exact same case, what extra lawyers' fees checks are we going to write?
Maybe about $5,000, something like that,
for
local
counsel.
For local counsel, Pro Hoc Vice Counsel, to sponsor us and get us admitted so that we can be first chair on the case. Yeah, it's usually $3,000 to $5,000 somewhere.
And there's some travel costs in there.
Yeah, okay, a couple plane tickets, hotels.
Andy likes to eat good, I've noticed, so a few $100 maybe for a steak or something. But it's not really that big of a deal for us to do even a major case. Okay, to be fair, we probably lose some money on the other side in terms of cases we would otherwise bill on that we can't bill on. But this is more than offset by the people paying $25 in the family plan or $35 a month in the regular AOR plan.
Yeah. Said another way, all of our attorneys are on salary already. We don't have to increase our costs at all in order to go somewhere in the country and handle one of these cases. Not like we are hiring a lawyer from scratch. We have to write them a flat check for some sort of a set fee or something like that. It's a different business model. And
Completely different.
This helps people understand, like, how are you guys able to do that? It's like
there may be some incidental.
We've shifted the paradigm.
Right. Okay, there's some incidental scene cleanup and counseling and maybe firearms replacement. It could be a bond. But at the end of the day, it's really not that big of a transaction cost for us to take even several of our lawyers who are on salary already. We are going to pay the salary and say, hey, we got another case. Let's go in there and crush the thing. That's what they want to do anyway. So it's easy for us to err on the side of saying, you know what, let's take it. It's a close call. Let's take it. What's the worst thing that happens? We do a great job for another client, get another 5-star review on the case. Okay, and we spend some time on a case we maybe didn't have to spend time on. But it was another case for us to do, and we get to, continue to sharpen our skills on cases, and it's always good to be in court more.
And continue to establish relationships with lawyers all over the country. That's been one of my favorite parts that I didn't expect to be as rewarding as it has been since we launched this program, Mark, which is whenever we go to a different state and do a case around the country, I love researching local counsel and finding like a really good Second Amendment friendly, pro-freedom, pro-firearms attorney in different areas of the country and establishing relationships with those people and learning from them and working with them. And it's been fantastic.
I wish we could talk about it, but you're getting ready to go to another state here very soon to meet a very high-profile, well-known lawyer in the Second Amendment community who's our local counsel on a case.
Who our client didn't pay a dime for because that is covered by the attorneys on retainer.
And I'm a little jealous, to be fair. It's going to be a fun trip and it's a fun case, but we can't talk about it. This is the downside, where other companies can come out there and if they want, even throw their...
Just trash their members.
They can trash their own members. They can talk about whatever they want to talk about because they don't have attorney-client privilege. Okay, but this comes with some benefits too. When you call our law firm on the emergency line, it's confidential.
It's not discoverable.
It's not discoverable. It's covered by attorney-client privilege. You're not going to get an argument by a prosecutor.
And just real quick, what we mean by non-discoverable. A prosecutor can't subpoena that information and get it and introduce it in your case against you.
A lot of people, in fact, we were on the phone today with a prospective AOR member who's really doing his due diligence. He went through the entire contract. He had about 6 different questions. He had written them out, sent it to us. Both of us spoke to him. I think he was a little surprised. We spent a long time with the guy. Those are the kind of AOR clients we want. The people who are researching this guy went through our Google reviews, right? He went and said, man, you guys got a lot of 5-star reviews. He said there were a couple 1-stars in there, but it was easy to tell they were crackpots. Very right. He said that to us on the phone.
Did, yep.
And so people who do their homework, and I said back to him, I say to the firm all the time, the more information that's accurate about our firm that gets out there to the market, the better it's going to be for us and our program. So I definitely encourage people to research the Attorneys on Retainer program. We've done a lot of videos now. There's a lot of information at attorneysonretainer.us. Also, find out about the Attorneys for Freedom Law Firm. Our firm has, at this point, been in business 27 years, right? If we were acting as shysters and ripping people off and doing a bad job, surely that information would be out there in the market after almost 3 decades of working at our law firm, at the same law firm. So do your research. There's a lot of information at attorneysforfreedom.com, but you can go outside, do Google, do Yelp, do whatever you want to do to get information about our firm and then make an informed decision.
And while we can't talk about specific clients' case without their permission, we have done a whole bunch of high-profile cases that people can go and research. Just a few Google searches around, and you'll find that we've been doing major national news, high-profile cases for many years.
It's a great point. Some clients have signed media releases, and we have had press conferences. I tried a case that was on national TV, was live from beginning to end. People can find that case if they want. They can start at the Attorneys for Freedom website, and there's a section there they can look at some of our high-profile cases. Some of them are so old that I don't even know if they could be found on the internet anymore, but there's a lot of information. You can watch me deliver an entire closing argument that was live on TV.
Yeah, absolutely. Okay, so I guess the summary answer to the question of how do we determine whether this is a self-defense incident for the purposes of AOR coverage is as long as we can make an argument in court that it was self-defense, and as we discussed, pretty low bar in order for us to do that.
If you try to act in self-defense, even if you blew it, we're going to have your back.
Yeah, and no other company out there can say that right now, because as soon as you blow it, now it's an illegal act and you're pretty much as good as disclaimed.
Yeah, one of the things I love about our contract, or we say fee agreement because we're lawyers, is in our fee agreement, there's a laundry list of all the things that are not excluded, and I encourage people to take a look at that and compare that as part of the piece of information. Look, I did a whole review tearing apart AOR as well, critiquing our whole program, and I think people really appreciate that. So there are things about other programs that they offer that we don't offer, and people might want that. We're not saying we're everything for everybody, but if it's a strong legal defense you're looking for with experienced criminal defense lawyers, we're going to have your back. If you try to act in self-defense, nobody can touch what we're offering.
With objectively the lowest chance of being excluded for one of the laundry list of reasons that other competitors may have. Sounds good. All right. Well, this has been attorney Andy Marcantel and attorney Marc J. Victor. Everybody go and check out attorneysonretainer.us and learn all about our awesome program and what it can do for you. Do your research, folks. As it turns out, and as we told this prospective client that we spoke to today, Marc, is that we usually find that the more research people do into these types of contracts, the more likely they are to sign up in our program.
Always.
So we strongly encourage people to research all of these programs. Our contract's right there on the website. Go read it. Check it out. Send us your questions if you have any. We're happy to answer them. Also, learn about our law firm and our philosophy and how we defend people at attorneysforfreedom.com. Go check that out. Learn more about us. Until next time, attorney Andy Marcantel and attorney Marc J. Victor. Peace.